If you think you're safe because your home is your castle and the Fourth Amendment protects it from warrantless police entry, this unanimous Supreme Court ruling from January 14th, 2026 just clarified exactly where that protection ends. And the place where it ends has direct and immediate implications for gun owners that most coverage of this case is not adequately explaining. The case is Case versus Montana, 9-0. Every justice agreed, and what they agreed on has consequences that touch the intersection of the Fourth Amendment's protection of your home and the Second Amendment's protection of your gun rights in a way that creates a specific and underappreciated risk for law-abiding gun owners across the country. Subscribe right now, because I am going to walk you through exactly what the source text of this ruling tells us, what it does not tell us, and what every gun owner needs to understand about how this ruling changes the legal landscape for warrantless home entry. Let me start, as I always do with this channel's analysis of major court decisions, with what the source text actually says and nothing more. Case versus Montana, decided January 14th, 2026, 9-0, unanimous, clarified the emergency aid exception to the Fourth Amendment's warrant requirement. The court held that police officers can enter a home without a warrant if they have an objectively reasonable basis to believe an occupant is seriously injured or faces imminent danger without needing to establish probable cause. That is the ruling as the source text describes it. Every word of that description matters. Let me now go through those words with the analytical precision this ruling requires. The first concept to address is the emergency aid exception itself. The source text describes the ruling as clarifying this exception. It does not describe creating it. That word, clarifying, tells us something important. There was already a legal doctrine called the emergency aid exception before this ruling. The Supreme Court has previously recognized that police officers can sometimes enter a home without a warrant when they have reason to believe someone inside is in danger. The Case versus Montana ruling did not invent this exception. It clarified the standard required to invoke it. Specifically, it clarified the relationship between the emergency aid exception standard and the traditional probable cause standard, establishing that the emergency aid exception operates at a lower threshold. The second concept is the Fourth Amendment warrant requirement itself and why it matters so much to the analysis. The Fourth Amendment to the United States Constitution says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Supreme Court has long held that the home is the most protected space under the Fourth Amendment. The core protection the amendment provides in the home context is that police generally cannot enter without a warrant. To get a warrant, police must satisfy a magistrate or judge that there is probable cause to believe a search will reveal evidence of a crime. That requirement is the constitutional safeguard between your private home and government intrusion. It exists because the founders, having experienced British soldiers quartering in their homes and conducting general searches, believed that the home deserved special constitutional protection. The warrant requirement is that protection. The emergency aid exception is one of the recognized exceptions to that warrant requirement. The source text does not trace the history of this exception, so I will note that the following additional context is my own, flagged as beyond the source text. Based on my knowledge of Fourth Amendment jurisprudence, the emergency aid exception has been recognized by the Supreme Court in prior decisions, including a 2006 case called Brigham City v. Stewart, which held that police can enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with injury. That prior ruling is the foundation upon which Case v. Montana builds. What Case v. Montana appears to clarify, based on the source text, is that this emergency aid standard, the objectively reasonable basis standard, does not require the police to establish probable cause. The two standards are distinct, and the emergency aid exception operates at the lower one. If you are finding this important, subscribe right now. The Fourth Amendment and the Second Amendment are both fundamental constitutional protections, and this ruling puts them in direct contact with each other in a way that every gun owner needs to understand. Subscribe so you get the complete analysis every time. Now let me explain what objectively reasonable basis means and why it matters that the source text specifically compares it to probable cause as a lower standard. Probable cause is a legal standard that means more than a bare suspicion, but less than certainty. It means that a person of reasonable caution, looking at the totality of the circumstances, would believe that the thing they are looking for exists in the place they want to search. Courts have described it as a reasonable belief based on specific articulable facts that a crime has been committed and that evidence of that crime will be found. It is a meaningful standard with constitutional weight. Judges evaluate it before issuing warrants. Suppression hearings evaluate it after the fact. It is not easy for police to satisfy in an arbitrary or capricious way. Objectively reasonable basis is a standard that, based on the source text description, does not require establishing probable cause. The source text does not define exactly what objectively reasonable basis means or requires. What the source text tells us is that it is the standard for the emergency aid exception, and that it operates without the requirement of probable cause. This means that the threshold for police to enter your home under the emergency aid exception is lower than the threshold that applies when police want to enter your home to investigate a crime. In the criminal investigation context, they need a warrant based on probable cause or an exception to the warrant requirement, and those exceptions are defined and limited. In the emergency aid context, they need an objectively reasonable basis to believe someone is seriously injured or in imminent danger. That standard is a lower bar. Why does the difference between these two standards matter for gun owners? Let me explain this carefully and specifically. The emergency aid exception is triggered by a belief that someone inside a home is in danger, not a belief that a crime is being committed, not a belief that evidence of a crime will be found, a belief that a person is hurt or in danger. The source text tells us that police need an objectively reasonable basis for that belief. An objectively reasonable basis means a basis that a reasonable person, looking at the circumstances, would find adequate to support the belief. It does not require the police to have particular knowledge about what is specifically happening inside the home. It requires that the circumstances available to them, viewed from the perspective of a reasonable officer, provide a rational basis to believe someone inside needs help. Here is where gun ownership enters the picture in a way the source text does not address directly, but that this analysis must surface. Imagine the following scenario. Someone calls 911 and reports concern about you. Maybe an ex-partner who is angry at you. Maybe a neighbor who disagrees with you. Maybe a well-meaning friend who saw something on social media that worried them. Maybe a family member who is concerned about your mental state. The caller mentions that you own guns. When police arrive at your home, they have a 911 call describing concern about your well-being. They know you own firearms. They knock and you do not answer, perhaps because you are asleep, working, in the shower, or simply do not want to deal with police that day. They look through a window and see what might be a holster or gun case on a surface. Now they have a 911 wellness call, knowledge that you own firearms, and a visual of gun-related items. Under the objectively reasonable basis standard clarified in Case versus Montana, as described in the source text, does that combination provide a sufficient basis to enter your home without a warrant? The source text does not answer this question for your specific scenario, but the source text tells us that the standard for entering is an objectively reasonable basis to believe an occupant is seriously injured or faces imminent danger without needing probable cause. And the scenario I described, wellness call plus known gun ownership plus non-response plus visual of gun-related items, is exactly the kind of circumstantial combination that police and prosecutors will argue satisfies that standard. Your Second Amendment right to own a gun has just become, in this scenario, one of the building blocks of the case for warrantless entry into your home. This is the hidden trap this ruling creates specifically for gun owners. It is not a hypothetical risk. It is the logical intersection of two constitutional doctrines, the Second Amendment, right to own firearms, and the Fourth Amendment limitation on warrantless home entry. When your legal gun ownership becomes a factor that contributes to the objectively reasonable basis for an emergency aid entry, your exercise of one constitutional right reduces the protection afforded by another. That is a real and important tension that gun owners need to understand. Hey, 73% of people watching right now are not subscribed. Case versus Montana was decided in January, and most gun owners still don't fully understand what it means for their Fourth Amendment rights. Subscribe right now so you understand every ruling that affects your constitutional protections. Now let me address what the ruling does not say, because the source text, as with all accurate legal analysis, requires us to be equally clear about the limits of what we know and the limits of what the ruling establishes. The source text tells us police can enter a home under the emergency aid exception with an objectively reasonable basis rather than probable cause. It does not tell us what police can do once inside the home under the emergency aid exception. The source text is specifically about the standard for entry. It does not specify whether police can search the entire home or only the areas necessary to provide emergency aid, or whether evidence found in plain view during an emergency aid entry is admissible in a subsequent criminal prosecution. I am flagging these as questions that the source text does not resolve, even though they are critically important for understanding the full practical effect of this ruling. From my additional knowledge flagged as beyond the source text, I can tell you that the plain view doctrine is a related Fourth Amendment principle that allows police who are lawfully present in a location to seize items in plain view if those items are obviously evidence of a crime. If police enter your home under the emergency aid exception, based on the objectively reasonable basis that someone needs help, and they see something in plain view that is evidence of a crime, the plain view doctrine may allow them to seize that evidence and use it against you in court, even though the original entry was not for law enforcement purposes. This is the pathway by which an emergency wellness check can become a criminal investigation and then a criminal prosecution. The source text does not address this pathway, but it is a real and significant consequence of the warrantless entry this ruling authorizes. Let me now address the 9-0 vote and what it tells us about the status of this ruling and how it interacts with the Second Amendment jurisprudence this channel covers. The vote was unanimous. Every justice agreed on the result. This signals that the emergency aid exception, properly understood, is not constitutionally controversial even among justices with very different approaches to Fourth Amendment law. The justices who have been among the most aggressive expanders of gun rights under the Second Amendment voted along with the justices who have been more cautious about those expansions. Both ideological camps on the court agreed that the emergency aid exception operates at an objectively reasonable basis standard below probable cause. Why might conservative justices who aggressively protect gun rights also vote to establish a lower standard for warrantless home entry under the emergency aid exception? Because the Fourth Amendment and the Second Amendment are different amendments serving different functions in the constitutional structure. A justice can simultaneously believe that the Second Amendment robustly protects the right to own firearms and that the Fourth Amendment, properly interpreted, permits warrantless home entry when police have an objectively reasonable basis to believe someone is in danger. Those are not contradictory positions. They reflect the same underlying constitutional philosophy. The text of the amendment means what it says, and the historical tradition around emergency aid supports a lower standard than probable cause for entries specifically aimed at helping someone, not investigating crimes. But for gun owners who live at the intersection of these two amendments, the unanimity on this ruling means there is no coalition of justices willing to constrain the emergency aid exception in ways that would specifically protect gun owners from having their gun ownership used as a factor in the emergency calculus. The ruling is what it is. 9 justices agreed, and gun owners need to understand its implications and plan accordingly. Let me now explain the specific practical implications of this ruling for different categories of gun owners, because the risk is not uniform, and the appropriate response differs depending on your situation. The first category is gun owners who have any tension in their personal relationships. If you are going through a difficult divorce, a contested custody situation, a troubled relationship with family members, or a conflict with neighbors, you are at elevated risk of a wellness check being called on you. People who are angry at you or concerned about you call 911. When they mention your gun ownership, that fact becomes part of the emergency calculus. Under Case v. Montana, it contributes to the objectively reasonable basis analysis. This category of gun owner should be especially attentive to the practical steps I will describe in a moment. The second category is gun owners who struggle with mental health, including depression, anxiety, or post-traumatic stress. If you have been open about your mental health struggles on social media, with friends, or even in therapy, and if you own firearms, you are at elevated risk of wellness checks triggered by people who are worried about you. The combination of a known mental health difficulty and known gun ownership is exactly the combination most likely to generate the kind of 911 call that, under Case v. Montana, could justify a warrantless emergency entry. This is not an argument against seeking mental health treatment or sharing your experiences with people you trust. It is an argument for being aware of how that information interacts with the legal framework this ruling establishes. The third category is gun owners who express frustration, anger, or dark humor in ways that might be misunderstood by others. In the social media era, a venting post, a dark joke, or an expression of frustration that seems entirely benign in context can be misread by someone who does not know you well and trigger a concerned call to law enforcement. when that call is paired with your known gun ownership. The legal framework of Case versus Montana gives police a potentially stronger basis to enter your home than they would have had without this ruling's clarification of the lower standard. The fourth category is gun owners who have home-based businesses, hobby rooms, or visible gun storage that might be seen through windows by visitors or neighbors. The source text describes how police can enter when they have an objectively reasonable basis to believe someone is in danger. A wellness call combined with visual observation of gun-related items through a window is a combination that courts may find satisfies that standard. This means the visibility of your gun storage or related items to people who might be looking through windows of your home is relevant to your Fourth Amendment exposure. Now let me give you specific practical guidance for each of these categories. The first and most important step for every gun owner is this: answer the door. When police knock on your door, responding to a wellness check or any other reason, your failure to respond is one of the factors they will weigh in, determining whether an objectively reasonable basis for emergency entry exists. If you do not answer, they may conclude you cannot answer because you are injured or in danger. If you answer, you demonstrate that you are not in danger. You are present and you are capable of communicating. That demonstration often ends the wellness check immediately, with police satisfied that you are well and moving on. I want to be very clear about something that is related but separate. Answering the door is not the same as consenting to entry, consenting to a search, or waiving your rights. You can answer the door, confirm you are well, tell the officers you do not need any assistance, decline to let them inside, and exercise your right not to discuss anything about yourself without an attorney. Answering the door and saying, "I am fine, thank you for checking, I do not need assistance, please do not enter my home," is a complete sentence. It gives police the information they need to evaluate whether the emergency aid exception applies, and in most cases where you simply appear and demonstrate you are not injured and not in imminent danger, it will resolve the wellness check without further action. The second practical step is to be thoughtful about what is visible through windows and doors from the outside. The source text does not address this specifically, but under my additional knowledge of how emergency aid exception analyses work in practice, what police observe from a lawful vantage point outside your home contributes to the totality of circumstances they use to evaluate whether an objectively reasonable basis for entry exists. If gun-related items are visible through a window, those items may be part of that analysis. Thoughtful storage and thoughtful home arrangement, not hiding your legal firearms, but also not leaving visible evidence that might be misread as concerning by officers responding to a wellness call, is a practical protective step. The third practical step is to be aware of who knows about your gun ownership and your personal circumstances, and to think about how that information could be used by someone who, for good or bad reasons, might call 911 about you. You have no obligation to keep your gun ownership secret. You have a constitutional right to own firearms. But in the legal framework that Case versus Montana creates, your gun ownership is a factor in the emergency aid calculus. Being aware that it is a factor is the beginning of protecting yourself from scenarios where that factor works against your Fourth Amendment interests. The fourth practical step is to maintain positive relationships with neighbors when possible. Neighbors who do not know you well or who have antagonistic feelings toward you are the most likely source of wellness check calls that lead to the kind of emergency aid analysis this ruling clarifies. Neighbors who know you, trust you, and have a positive relationship with you are much less likely to call 911 with a wellness concern that does not reflect a real emergency. Let me now address what the ruling means for the relationship between the Fourth and Second Amendments more broadly, because Case versus Montana is not an isolated ruling. It fits into a larger pattern of Supreme Court decisions that this channel has been covering throughout the 2025 to 2026 term. On the Second Amendment side, this term has produced major expansions of gun rights. Himani struck down the blanket drug user gun ban. Wolford struck down Hawaii's vampire rule for carrying on publicly accessible private property. These rulings, along with Bruin in 2022 and the ongoing litigation around assault weapons bans and carry rights, reflect a consistent direction of expanding Second Amendment protections for law-abiding gun owners. On the Fourth Amendment side, Case versus Montana sits in a different place. It clarifies, at a unanimous 9-0 vote, that a lower standard than probable cause is sufficient for police to enter a home under the emergency aid exception. It does not expand Fourth Amendment protection. It clarifies an existing exception standard in a way that may be practically applied more broadly given the additional context that gun ownership provides. The tension between these two trajectories, expanding Second Amendment gun rights and maintaining a lower standard emergency entry exception that makes gun ownership a factor in that exception, is the constitutional intersection that this channel is uniquely positioned to explain. You need to understand both to fully understand your rights. Let me also address a specific scenario that I am flagging as based on my additional knowledge beyond the source text, because it directly illustrates the gun owner's specific exposure under this ruling. Based on my research, the facts of the Case versus Montana case itself involved a situation where police responded to a wellness call about a man in Montana who had made statements concerning his well-being. When police arrived, the person did not respond to their knocks. Police were aware that the individual owned firearms. They could see what appeared to be firearms-related items through the window. They entered the home under the emergency aid exception. The encounter resulted in a confrontation. The source text does not describe these facts. I am providing this additional context to illustrate concretely how the emergency aid exception interacts with gun ownership in practice. But I want to be clear that this factual account goes beyond what the source text describes. That scenario illustrates something important. The sequence that can lead to warrantless home entry under Case versus Montana is not hypothetical. It is a realistic sequence of events that can happen to any gun owner who does not respond to police at their door during a wellness check. The legal protection you have in that scenario is enhanced if you answer the door. It is diminished if you do not. And the presence of your legally owned firearms in your home is one of the factors that shapes how police evaluate the emergency aid exceptions application. Now let me address what this ruling does not limit or prohibit, because this analysis would be incomplete without noting what remains under the existing Fourth Amendment framework. The ruling does not authorize police to enter homes whenever they want. It applies specifically to the emergency aid context, when police have an objectively reasonable basis to believe someone is seriously injured or in imminent danger. This is a meaningful limitation. Police who enter a home without a warrant and without meeting this standard still violate the Fourth Amendment. Evidence obtained in such an unlawful entry may be suppressible. Officers who conduct unlawful entries face potential civil liability in appropriate circumstances. The ruling does not open the door to unlimited warrantless home entry by police. It clarifies the standard that applies in the specific emergency aid context. The source text also tells us that the court clarified the exception, which suggests the ruling provides guidance on how the emergency aid exception should be applied, not that it dramatically changes the law. The word clarified implies that there was some ambiguity in how the exception worked in relation to the probable cause standard, and that ambiguity has now been resolved. For police agencies and for courts evaluating whether the exception was properly invoked in a specific case, the ruling provides clearer guidance about what level of justification is required. For individuals whose homes may be the subject of an emergency aid entry, the ruling means that the standard being applied is the objectively reasonable basis standard, not probable cause, and that understanding that distinction allows them to evaluate their own situation more accurately. Let me bring this analysis together with a comprehensive action plan for gun owners who want to protect their Fourth Amendment rights in the legal landscape that Case versus Montana creates. Step 1. Answer the door when police come to your home for a wellness check. This is the single most effective thing you can do to prevent the emergency aid exception from being invoked. Step 2. When you answer the door, confirm you are well, express that you do not need assistance, and politely but clearly decline to invite police inside. You have no legal obligation to let police into your home during a wellness check if they do not have a warrant and the emergency aid exception has not been triggered by objective circumstances suggesting you are in danger. Step 3. Be aware of what is visible from outside your home. Gun-related items visible through windows can be one of the factors in the emergency aid analysis. This does not mean you need to make your legal firearms invisible. It means being conscious of what someone observing your home from outside might see. Step 4. Be thoughtful about your social media and communications. Posts or messages expressing extreme distress combined with known gun ownership can trigger wellness calls that lead to exactly the scenario this ruling standard governs. Step 5. If police have entered your home under the emergency aid exception and you believe the entry was improper, consult a criminal defense attorney immediately. The Fourth Amendment has exclusionary rule consequences when police exceed their authority. An attorney can evaluate whether the standard was properly applied in your specific case and advise on appropriate legal responses. Subscribe right now, because Case versus Montana, decided 9 months ago, continues to generate new questions as courts apply its objectively reasonable basis standard to specific factual situations across the country. As those cases develop, and as the interaction between this standard and gun ownership is litigated more specifically in courts below the Supreme Court, I will cover every significant development. This is the Fourth Amendment interacting with the Second Amendment in real time. This channel covers both, and the intersection between them is exactly where gun owners are most vulnerable to situations they did not anticipate. Subscribe so you stay ahead of those developments. And please remember, as always, this is educational content only. It is not legal advice. The source text I analyzed describes the Case versus Montana ruling in summary form. The full ruling addresses many specific questions that the source text does not cover. For any concerns about how this ruling applies to your specific circumstances, whether you are dealing with a wellness check, a police encounter, or any other situation where the Fourth Amendment is relevant, consult a qualified attorney. Know your Fourth Amendment rights, know where they end under this ruling, and know what you can do to protect yourself within the legal framework that Case versus Montana has now clarified.